All right, guys, we got some big breaking news that just came down now. The Supreme Court has basically taken a sledgehammer to the EPA's authority. So the Environmental Protection Agency is now strictly limited when it comes to protecting the environment. So the whole thing, the whole reason why it exists is now completely undermined. This is in the New York Times. Supreme Court curbs EPA's authority to address climate change. The decision was a blow to the Environmental Protection Agency's powers under the Clean Air Act. It was the latest ruling by a court that has handed down significant decisions on abortion and guns. The Supreme Court on Thursday limited the Environmental Protection Agency's ability to regulate carbon emissions from power plants, dealing a blow to the Biden administration's efforts to address climate change. The vote was 6-3, with the court's 3 liberal justices in dissent, saying that the majority had stripped the EPA of the power to respond to the most pressing environmental challenge of our time. The ruling appeared to curtail the agency's ability to regulate the energy sector, limiting it to measures like emission controls at individual power plants and, unless Congress acts, ruling out more ambitious approaches like a cap-and-trade system at a time when experts are issuing increasingly dire warnings about the quickening pace of global warming. The implications of the ruling could extend well beyond environmental policy and further signal that the court's newly expanded conservative majority is deeply skeptical of the power of administrative agencies to address major issues facing the nation and the planet. So this is what I was talking to you guys about in the Roe versus Wade decision. We've now entered a new Lochner era. The Lochner era was when the Supreme Court was judicially activist but politically conservative. So they legislated from the bench, but in a conservative direction. During the Lochner era, they said an employer and an employee have what's called a right to contract. So the government is not allowed to step in and say, hey, here's some child labor laws. The government's not allowed to step in and say, hey, you need to pay that person more for overtime. The government's not allowed to step in and say, here are minimum wage laws. Here's limits in terms of how many hours you can work somebody. Here, all these, the labor protections that the government put into place were viewed as by definition unconstitutional because that's a third party intervening in the right to contract between an employer and an employee. It was a horrendous era, and it took the New Deal era to come along and wipe that shit out. Now we've re-entered a Lochner era, and their decisions, one after the other, are horrendous. So they say that skepticism has been evident in recent decisions arising from the coronavirus pandemic. The court ruled, for instance, that the Centers for Disease Control and Prevention was not authorized to impose a moratorium on evictions, and that the Occupational Safety and Health Administration was powerless to tell large employers to have their workers be vaccinated or undergo frequent testing. The question before the justices in the new case, West Virginia versus Environmental Protection Agency, was whether the Clean Air Act allowed the EPA to issue sweeping regulations across the power sector. More broadly, the court was asked to address whether Congress must speak with particular clarity when it authorizes executive agencies to address major political and economic questions. The court has called the inquiry the Major Questions Doctrine. Last year, on the last full day of Donald J. Trump's presidency, a federal appeals court in Washington struck down his administration's plan to relax restrictions on greenhouse gas emissions from power plants. The Trump administration said the Clean Air Act unambiguously limited the measures the agency could use to those, quote, that can be put into operation at a building, structure, facility, or installation. A divided 3-judge panel of the court, the U.S. Court of Appeals for the District of Columbia Circuit, ruled that the Trump administration's plan, called the Affordable Clean Energy Rule, was based on a fundamental misconstruction of the relevant law, prompted by a tortured series of misreadings. The EPA has ample discretion in carrying out its mandate, the decision concluded, but it may not shirk its responsibility by imagining new limitations that the plain language of the statute does not clearly require. The panel did not reinstate a 2015-era Obama regulation, the Clean Power Plan, which would have forced utilities to move away from coal and toward renewable energy to reduce carbon emissions, but it rejected the Trump administration's attempt to replace that rule with what critics said was a toothless one. The appeals court ruling also cleared the way for the Biden administration to issue stronger restrictions. The Obama-era plan had aimed to cut emissions from the power sector by 32% by 2030, compared with 2005 levels. To do so, it instructed every state to draft plans to eliminate carbon emissions from power plants by phasing out coal and increasing the generation of renewable energy. The Clean Power Plan never came into effect. The Supreme Court blocked it in 2016, effectively ruling that states did not have to comply with the measure until a barrage of lawsuits from conservative states and the coal industry had been resolved. That ruling, followed by changes in the court's membership that have moved it to the right, has made the environmental groups wary of what the court might do in cases on climate change. So, look, what we're dealing with here is it's basically death by 1,000 cuts to the administrative state. So in other words, you have something like the Clean Air Act. It delegates to the Environmental Protection Agency, protecting the environment, keeping our air and water clean. And then the Supreme Court turns around and said, look, all these new rules and regulations that you just came up with under the Clean Air Act, well, we think you're delegating too much broad authority to the EPA to do stuff like protect the air and protect the water. So therefore, we're going to nitpick every line, every sentence, every comma, and we're going to say, this part's unconstitutional, that part's unconstitutional, this part isn't interpreted properly, that part's not interpreted properly. So I guess we just have to throw the whole thing out and take away the authority and the ability of the EPA to do what the EPA does. See, the old school understanding, the common sense understanding is, if Congress lays out some sort of framework for clean air, clean water, then you have the people at the EPA can implement those regulations and do so with the expertise that they bring to the table. But now the Supreme Court says, no. If you're bringing expertise to the table and you're regulating, for clean water or clean air in a way that doesn't go by the very letter of whatever Congress authorized, well, then you're overstepping your authority, you're overstepping your power, what you're doing is not allowed, and we're going to strike it down. And this sort of logic can be used to just destroy every single regulatory agency in the entire country. So basically what you're doing is you're setting up a system where it's unfettered, free market, laissez-faire capitalism without any rules or regulations, and you're doing it under the guise of this is the only system that's allowed because it's the only system that's constitutional. So any sorts of regulations, whether it be of Wall Street, the marketplace, for the environment, etc., they say no. Unless it is specifically delegated by Congress in a way that's so absurdly specific that they don't even have the ability to write it out in the way that they need to, well, then you're screwed. Then we're just going to strike down the EPA's ability to do stuff like protect the environment. The new Lochner era is in full swing. And I said it once before, I'm going to say it again. Understand something, guys. If Democrats don't act, then they're accepting the fact that a group of unelected elites have gone full rogue authoritarian and have ended democracy as we know it. I mean, that's the bottom line. If you look at this and you're not thinking of ending the filibuster, if you look at this and you're not thinking of expanding the court, if you look at this and you're not thinking of requiring unanimity for judicial review, then you're useless. And you're less than toothless, and you're the Washington Generals, and you're prepared to lose from now until forever. Because the way that this Supreme Court is acting, I want you to understand something. It doesn't matter who's president if you don't reform the court. Because here's why. A President Bernie Sanders can get in there and say, we just passed free college, or we just passed Medicare for all. And then there'll be 1,000 lawsuits. It'll go to the Supreme Court, and the Supreme Court will find a bullshit rationalization to turn around and say, well, actually, you're not allowed to do free college. You're not allowed to do Medicare for all. You're not allowed to do a public option. Or you're not allowed to raise the minimum wage because of reasons and stuff and things, and it's unconstitutional because if you look at this letter in paragraph C14, then this doesn't line up with the way that you interpreted that, so sorry, we got to throw it all out. That's effectively what's going on here. And I need everybody to understand that. So they've gone full rogue authoritarian. There is no more debate about it. And if people don't act, then it's all a waste of time. If the Democrats don't act, then this is all a waste of time. Because you're going to run against a brick wall. No matter who's president. Doesn't matter if it's Bernie Sanders. Doesn't matter who it is. They will continue to run against right into a brick wall because the Supreme Court will look for any rationalization to say anything you're trying to do is unconstitutional. So that's what we're dealing with. I wish that the news was less terrible and less absurd, but the fact of the matter is the Supreme Court is ruling that the EPA, the Environmental Protection Agency, can no longer protect the environment.